Okay. Agency brokerage. All right. This is similar to the ones that were in my class last night, similar to some of what we did. What we're going to talk about. We're going to talk about agency. It's the legal relationship in which one party, called the principal, authorizes another, called the agent, to act on the principal's behalf in dealing with third parties. So, typically, our broker is who we work for, and every one of us works under the broker as an agent. The broker is an agent, as well as everybody that works under the broker is an agent, and we work for the principal. That's the buyer or the seller. They're our primary customers. And we're going to act in their behalf in dealing with third parties and trying to negotiate this contract to get the deal done. So in all states, the agent appointed to sell or buy real estate has to be licensed. So they talk about trying to give people tip fees, referral fees. They'll hold you to the fire on this in the state of Ohio. If you try to give tip and referral fees to people that aren't licensed, you better call it something else, because you can be found wrong by doing that because they're not licensed. So everybody that gets buying and selling real estate and getting paid to do it has to be licensed. The real estate agent does not have the power to contract on behalf of the principal. So we never sign anything for the buyer or seller. We're only giving them the paper, bringing the paper to them to buy or sell. We verbally can commit and say, oh yeah, they'll take it, or yes, that's an acceptable offer. But until the actual buyer or seller signs anything, that's not a deal done. It's not a commitment. So when we're verbally committing, we need to tell the people whose behalf we're doing this, I think it'll work, but I got to take it back to the buyer. I got to take it back to the seller. But I'm pretty sure we can have a deal here. But you can't say, we're done. You've got to wait until you get the buyer and seller signatures. So the agency is created by an agreement. We went through some listing agreements last night. We're doing selling agreements. We're doing buying agreements. Again, express. It's in writing. The broker is an agent who, for commission or fee, brings parties together to negotiate, conducts negotiation, and complete the transaction, usually involving the sale or exchange of property or the acquisition of contract rights. And so leasing, buying, selling real estate, apartments, commercial, industrial, can be any kind of property. The agent is an independent contractor. They're a person who is retained to do a job and invoke judgment as to how the work will be done. This is where you're bringing your knowledge and your professionalism and your expertise to the fore, but you are an independent contractor. Now, there are people that work for brokers, that work for agents that might be salaried, but for the most part, our agents are always independent contractors. So that means commission only. The listing is a contract between the seller of real estate and the broker, authorizing the broker to secure a buyer for the property on specified terms in return for a fee if the broker is successful. So we're taking the listing agreement. We're putting the contract together. We're going to go through and we're going to check all the boxes. That's where we're going to find out what are the specified terms. What are the terms that the seller is willing to live with that we have to put in our contract that the seller says we have to have in order to do this? The price, the time, what contents will go with the property, all those kinds of things are part of this. Will the buyer do or seller do financing? That will be all part of these terms. The exclusive agency, the listing in which the seller gives one broker the authority to procure the buyer for the property, but also retains the right to procure a buyer for the property themselves. That's exclusive agency. There are agents in our market that don't work on exclusive agencies listings because they feel they won't be paid. They go to all this work, they get the property teed up, they do the competitive market analysis, they put time in, they market, they put it all listed, do everything, and then the seller brings their brother in and sells them the property. That person then would not get paid under the exclusive agency. Under the exclusive right to sell, This is a listing in which the seller gives the broker authority to procure a buyer for the property. The broker is entitled to commission even if the buyer is procured by the seller. This is usually this exclusive right to sell is the one and the only contract most of our agents work with because they want to make sure they're going to be paid for their time, their effort. Open listing is a listing that entitles the broker to compensation only if his or her activities bring about the desired results. So an open listing would be compared to a for sale by owner. For sale by owner, brokers, agents bring buyers. That's when they earn their fee. They'll get a half fee, and we call that an open listing. Net listing, where the broker earns a commission based on net amount seller wants to clear. In Ohio, we don't allow those formal type net listings. We do not allow that practice in Ohio. It is allowed in other states. So if you see something on your test that says net listing, just know not happening, not allowed in Ohio. Multiple listing service, an organization which brokers have contracted with each other to share their exclusive listing contracts. To work through the MLS, to be able to list through the MLS, you belong to the Board of Realtors. You pay dues. You agree to their policies. Their policies say when you list on the MLS, you're sharing your listings with the entire brokerage community. You're opening your listings to them so they can bring you buyers. Doesn't mean they're actually going to be successful, but we're sharing all the listings. It's an open market. And again, years ago, we didn't have all these internet tools. The MLS was only accessed by real estate agents. So the only way, we didn't do, most FSBOs, if they didn't sell within a certain period of time, it was real easy for an agent to convert them and get the sale contract, because the owners that were trying to sell on their own would say, well, let me try to sell it myself for a couple weeks. If I can't do it, then I'll give you the listing. Today, they'll say, well, let me list it here. Let me do this. Let me try this before I give you the listing. The world out there is a much bigger place where people can do their own work without agents. What you need to do is prove to them why they need you, why they need your expertise to help them get the deal done right. And we can almost always tell people that by using a realtor, they're going to get a better price. It'll be a better transaction. It's more experience, better done. The authority, the term used in the law of agency denoting the agent's power to perform acts authorized by the principal. So express authority. Authority of the principal confers on agent explicitly in writing. Now it says here it can be conferred orally in writing. In Ohio, that has to be in writing. All listing agreements have to be in writing. The implied authority is the agent's authority to do things necessary and proper to accomplish the express terms. Again, that's bringing your market knowledge in, your expertise in, everything you're going to do to help make the sale transaction you're bringing to the table. You don't have to have all that spelled out in the contract. Those are your duties. Those are the things you know how to do as an agent. The broker's duty as a seller, good faith and loyalty, requires the broker advance the principal's interest, even at the expense of his or her own. That's that whole fiduciary thing. All faith and loyalty, put them on a higher pedestal. We take care of everything they need at the expense of our own, meaning we're not going to be involved in a transaction, meaning we might have to miss an important date or something. We might be missing something else while we're taking care of our client's responsibilities. Skill and care, you have liabilities and remedies that go with that. There's skill and care, you're liable if you don't do it right. There's remedies that they can come back and seek remedies from you legally if you don't do the skill and care. The broker's duty to the buyer. Traditional real estate sale, the seller lists the property with a broker. The listing authorizes the broker to act as the seller's agent in procuring a buyer for the property. The buyer is a third party. In negotiations with third parties, the buyer, the broker, is acting on the seller's behalf. Okay, old days. Everything the agent did, they were doing on behalf of the seller. We always assumed that they were doing it on behalf of the seller because the seller is paying their commission. Before we had agency disclosure, before we said, wait a minute, stop. I'm not going to work for the seller. I'm working for you, the buyer. This was always where it was assumed this was going in this direction. The broker is acting on the seller's behalf. However, sellers' brokers are liable to buyers in some situations. What did we talk about last night where sellers' brokers are liable to buyers? What do they need to disclose? The agency, material defects. If an agent is aware of material defects with the property, even though they're working for the seller, they have to disclose it to the buyer. Because if they don't, they'll get sued. When the buyer finds out, they'll get sued. The house is flooded before. We don't see the watermarks anymore, but the house has been flooded. There's a wiring problem, and I hired an electrician to fix it. I hope he fixed it. But it's things like that, problems with the house. We have seller disclosure forms, property disclosure forms. We make sure they fill them out right. As a selling agent, we want to make sure they are totally filled out right. But if they're not, we tell the sellers, you have to put these on this form. No, I don't have to broadcast and advertise it to buyers that these are problems with the property as long as it's listed on that form. But if you don't list it on that form, I'm going to tell the buyer. I have to tell the buyer. Yeah. Right? As a courtesy, you would, anytime you're an agent dealing in real estate, if you're just representing a family member but you don't actually have a real contract, you're kind of acting in everybody's interest, you would tell people what your skill and your background is. You're better off being upfront with that.
I thought only if they add said when you disclose.
No. When I'm a broker, even on a sign, I have to put the sign, the property's for sale by me as the broker owner. If I'm a broker, if I'm an agent, I don't have to put it on my sign. I don't have to advertise it, but I have to tell anybody that comes to me that I'm an agent selling my own property or selling a property that I have an interest in. That's why I said I advertise on my sign. I'm selling my own property. I'm a broker. I'm telling the world that I have a broker's license, that I have that skill, that I've achieved that designation, in essence.
So a lot of listings you'll see it says owner agent.
Yes, owner agent. But, and for me, as a broker, I'd actually put broker agent. It's a step higher than owner agent. They want the word, you have to tell everybody you're a broker. Because you've gone that much further, there's more liability. You have to tell everybody what you know. Buyer's agent, agent who is contracted to locate real estate for a buyer. The dual agent, transaction which the agent represents a buyer and seller. Designated agent, transaction whereby the dual agency is avoided by a broker designating one agent within the firm to represent the buyer, another to represent the seller. So the broker says, I've got a Chinese wall. These guys aren't going to talk. They're not going to use the same copier. They're not going to be to see each other's files. This guy's going to only represent seller. This guy's only going to represent buyer. And they're not going to talk at all in the office.
Is that pretty common?
To have dual agency?
Designated agent.
Yeah. Because when you're listing a house, and you can also do this when the open house happens and somebody walks in, they want to buy the house. Okay, I got a little bit of time. I'm going to declare dual agency, and I've got permission from the seller that I'm going to do this. I'm going to tell the person coming in the door that I'm going to be a dual agent.
No, but the designated agent.
But I mean, I have an open house, and I'm listing the house. But my friend who works in the company with me brings the buyer in.
Yeah.
That's how they're working for the same broker. And they have to, then at that point in time, the broker has to specifically say, I'm designating, you're going to represent buyer, you're going to represent seller. They tell everybody, we're working for the same broker.
It seems like that would happen a fair amount.
It does. It happens a lot. Yeah, that's why when before that property ever gets listed, we actually show the houses to our own brokerage inside our firm. We'll have special open houses inside our firm. Pre-listings. We'll tell everybody what's going on. We try to do pre-marketing. And yes, that's when our buddy brings the buyer to the table. It happens a lot. And then what I've seen lately now too, to be listed soon. Okay, we saw, and I'm seeing these more signs now, to be listed soon. Okay, because they're trying to compete with the Zillows and the other things like that now to say, okay, it's not ready to be listed yet because they haven't cleaned, they haven't done whatever they're going to do, but they've already contracted with me. I'm putting the for sale sign up, and I'm telling everybody it's not ready yet, but it'll be listed soon. And then I'll see that to be listed soon, and next week I'll drive by and I'll see for sale. So that's a new thing I've seen in the marketplace. Designated, okay, transaction agent, independent contractor status, only responsibility paid is to conclude the deal. Ohio doesn't do transaction agents either. It's only working in a certain capacity. So Ohio just doesn't do it that way.
Is it like a facility
Yeah. When you're a dual agent, you become a transaction agent as a nature because you're not allowed to negotiate on either behalf of either party. But you can't enter the transaction just to facilitate only the paperwork. Now, these things that the Redfin's doing, the other brokerage firms are doing for less and less money, when they do work for less and less money, they also offer less and less services. So they're not necessarily offering the full complementary services of what a full agency will do. So I don't know at what level they can step down, and they're just doing that.
No, I've had an agent before, sold my house, then he helped me buy a house. Then when I sold that house, he did where he only charged me 4% total. So 1% for him and 3% if somebody brought in. I mean, so
He already made his money off of you,
right. So now
and he was doing that as a favor to you. And guess what? You'll probably use him again.
Yeah. Well, it went to my husband's daughter. He went to,
Yes.
He's been recommended 3 more times.
So, and that's why they do that. That's a legal way that they can offer a discount for special customers. And that's totally legit. They're allowed to, again, it's a negotiable fee. They don't have to be full fee to do the work. If they know firmly they've already got money from you, they can work for you for 1%, and they know they're going to keep working for you. That's totally legit. But that's not transaction agent either, because they were representing you. They went through the entire, they didn't shortchange anything. They were still doing everything they're supposed to do. Broker's commission. Disputes over commission generally involve 2 questions. Has the broker completed the work that he or she was hired to do? So this is at the sale closing table. The people that are there trying to write the check are saying, well, did they really do their job? And then the other is when the broker's job has been accomplished so as to entitle them, or when has the broker's job been done? Okay, when the broker's job has been done, when it's been a ready, willing, able buyer, when the seller breached, that's when the broker's still entitled to money. When they got a ready, willing, able buyer and the buyer breached, the seller can't be expected to pay because the transaction didn't close. But if you're representing the buyer and you had a buyer contract, you may be able to go back after the buyer for money. That's this dual agency world. Procuring cause. This is another dispute. Okay, who brought them in? Who started the transaction? What started that chain of events? Again, like I said, in my world, we learned it as a threshold theory. The broker had a threshold, agent had to threshold them through the door. That meant they were theirs. They couldn't just drive them by. They had to literally bring them in the door and say, this is my client. I'm bringing them in the door. I deserve commission. They were introducing them to transaction. Very formal. Today, procuring cause might mean you pass a listing on to them. You give them the lead. There's a lot of things that can be considered procuring cause. And in the definition, procuring cause means you initiated action. That's all it is. What's initiating action? That's a lot of questions asking. That's why the broker's commission at that point in time, somebody says, did they really earn their money? What did they do to initiate the action? Well, they gave you the lead. They showed you that this was available. They sent you information on it. That's enough to get money these days. Ready, willing, and able. Capable of present performance. Test whether the buyer is ready, willing, and able turns to the intention of the buyer at the time the contract is made. The buyer is considered financially ready and able to buy under any of 3 conditions. They have cash on hand. The buyer has sufficient personal assets and a strong credit rating that ensures that they should get reasonable credit worthiness and be able to facilitate it. The buyer has a binding commitment for a loan with which to finance the sale. Again, when you're working in the buyer's market, that's one of the first things you want to do. Get a loan commitment. Figure out what these people qualify for. Make sure they have a loan commitment so when you're out looking at properties, you can present a contract to somebody and they have the ability to say, I can get financing. It's a legitimate deal. Max, my son, when I said, you need to figure out what you qualify for before you even look. Well, I want to look at this rate. I said, no. What do you qualify for? What you think you qualify for and what you actually qualify for can be 2 different things in our marketplace. You might qualify, you might think you can afford 130, but you only qualify for 110. 2 different worlds of looking at real estate. So again, make sure they go through that whole process. If you're going to help a buyer out, make sure they're qualified You're showing them what they're qualified and able to buy. They are ready, willing, and able financially.
Do you guys here in this market have relationships with bankers? Is there some type of working relationships so that you can send clients to certain people that are pre-qualified?
Mm-hmm. Okay. He was asking if we have relationships with bankers. Yes. Any good agent, any good broker can give you a list of business cards and say, these are people that I recommend you go to. This is how you build your book of business. What Tuesday night we had Hunter in, and he gave this presentation. And you, as an agent, are going to have this little list of your references, all kinds of lists for brokers, for inspectors, for finance companies, for everybody that's moving contracts, everybody that's involved, fix repairs. Each agent is going to have that little list, their little Bible of people that they'll refer, because that's what's going to make them good at what they do. They can give referrals like this all the time. They have a list of people that are able to help out, get a transaction done. And the more you're in the business, when you first start out, you're going to go to your broker. You're going to ask for those referrals. You're going to go to other agents that you're in the shop with. Who are the people you use? Who are the people you recommend? Let's share your list with me. Again, these are resources. You want, and as you're in the business longer and longer, you get those relationships. You get those good resources. You want to know who they are. You want to share those people because those references will help you with your business, help you close. When commission is earned, most states the broker has procured the buyer when the broker submits the binding enforceable offer from the buyer on the seller's terms. So everybody had to agree and actually had to sign the contract. Just because you made an offer and you think they were under the seller's terms, until the seller accepts, they're not really on the seller's terms. So you have to have that contract accepted. That's when you really have earned your commission. That's when you're ready to go. Now, it says here, as long as the buyer is financially able, the brokers earn the commission. I'm sorry, that won't hold up here. You have to have people commit to a contract. Once the contract is committed to, then you've earned the commission. Just by thinking you've brought the right people that qualify and everything else like that, again, there's all these contingencies, all kinds of fine language in a contract. Everything has to be accepted. The agency terminates based on the personal service concept. Again, you don't like what I do, we will tear up this contract. Give me a day notice and I'll tear it up. I'm not going to be your agent anymore if you don't like what I do. It behooves you to work with people that want you to work for them. So it can be terminated by acts of the parties, by operational law, or agency couplement interest, agency relation in which the agent is given an interest in the subject of agent's property. That doesn't happen that often, but if the agent does get an interest in it, they need to remove themselves from that whole agency relationship. That's a totally different type of transaction. The real estate sales associate, person employed by a real estate broker who is under the broker's direction, lists and sells real estate. You are under the broker's direction, meaning he will tell you that sales meetings you need to attend. They'll work with you to establish goals to get sales done. They'll tell you you have to work certain hours in the office. You're still an independent contractor, even though they're telling you these things, because they're not saying you got to be in here 8 to 5. They're saying we need you to sign up for office time. We want to work with you to establish goals that you can do and carry on your business this way. And hey, if I'm your broker, I want to make sure you're doing things legally and right. I'm going to watch what you're doing, because when you're out there as my agent, you're acting for me, and I can get sued by anything you do wrong.
Do they pay you to work in the office if they tell you to come in and work from like 4 to 8 p.m.?
No. The reason you want to work in the office is because you want to be there answering the telephone. When somebody calls and they don't ask for a specific agent, that becomes your lead. By answering the phone, you're getting leads.
But you're not getting
No, that's part of commission only, but you've got FaceTime. You're getting leads. That's the reason for doing it. They're not going to ask you to work 40 hours. They're going to say, I expect you to work a couple hours on a Saturday or a Friday or whatever to do some phone time. Okay, they want to make sure the office has coverage for typical business hours for an agency. Licensing laws. State laws require a person to obtain a license to act as a real estate broker or sales associate, and regulate the conduct of those who act as brokers or sales associates in real estate transactions. That's the Ohio Division of Real Estate. They are the agency that enforces the laws, creates the laws, and carries all this stuff out. The unauthorized practice of law. Agents and brokers are not allowed to be lawyers. We're not allowed to write legal contracts. We are totally allowed to take the Board of Realtor contract and fill in blanks. They expect us to do that. The broker is not entitled to charge a separate fee for any legal work that is permitted. Filling in blanks in a contract is the extent of the legal work that's permitted. Seriously, that's all we're allowed to do. I was playing with contract the other day to do a roof, and I actually left part of it the way it was. The guy, my asset manager, called me back and he said, Joyce, you're supposed to change this and do that. I said, but you gave me all these other conditions. I'm not a lawyer. And I told him that. I said, I'm not a lawyer. You gave me all these other conditions. What do you want me to do here? He said, well, I expect you to take the brackets off, change it, take it out of italics, make it bold. Let the contracting party come in and make recommendations. So he took the whole legal piece out of it. So then I was just taking a form contract and carrying through. So he took me out of my legal loophole. What?
So, I'm sort of like added the contingency.
They're in the contract.
Yeah, but if I provide for.
They're check boxes. Or
Okay.
it prompts you through that. In our Board of Realtor contract, it prompts you through all those contingencies. You're not adding and making up a whole list of contingencies. They're already in the contract.
I see just checklists.
You're just checking off what pertains or filling in the blank with the number.
But I have to remember that.
Please,
But I would have to be a member to have the opportunity to get it.
whatever broker you work for is going to have contracts for you. So if you're working for a broker, they're going to have contracts for you. If you're working on your own as an investor, you've already been to a broker though. You've already had a broker relationship to get your license. This is a person you want to sit down and say, this is really what I want to do. I want you to help me be an investor. I'll do a little bit of work for you, but I want you to help me be an investor. I want you to help me have access to contracts and things that'll help me do this. And I'm still working, quote, under you a little bit for some time. You're going to get a piece of what I'm doing. So you would have that conversation with them. You're not ready to give up that money yet, but that's the conversation. That's where you're going to go to get your broker relationship started. You need that broker to sponsor you. So you need to have that understanding.
Hey, Joyce, can't you get some of those legal forms like online, just so like those KVs?
Yeah, but they don't really work in Ohio as well as you'd like them to. Our Board of Realtor contracts have been tried in Ohio by both sides. They're really good contracts. They hold up in a court of law. And they're accepted by any agent in Ohio that's doing business. And anybody that you're going to come across that might be part of the transaction or piece of the transaction that's done anything in real estate has seen these contracts before. You bring something new into the play, it's kind of like, okay, who's going to be the attorney that's going to review that for them? Where's this going? So that's why we strongly urge that you use the board contracts. Commercial, totally separate. But with commercial, we hire attorneys to do that for us. Electronic world, part of what he talked about the other night. We have social media, we have websites, we have electronic contracting. We also have prohibited communications, which any broker will talk to you about the prohibited communications, the way you're supposed to conduct your business. When somebody tells you, I do not want you to call me, take me off the call list, there is no call list, there's all kinds of things like that that are prohibited communications. And that's it for this chapter. Any questions?
What's the difference between like an agency and a broker, or agent and a broker? How much more schooling does a broker have, or what else?
A broker has to take at least 6 real estate courses, at least 25 sale transactions, and a number of years of business, and the extra broker exam. So you're taking a whole nother exam. But to be an agent, you're just taking 4 real estate courses. To be a broker, you're taking the 2 more classes, like I said, and you have to have a number of years of experience to have minimum transactions. And the Ohio Division of Real Estate, if you're real curious, go to the Ohio Division of Real Estate website and you'll see the list. I got my agent license in 83 and I got my broker license in 87, 89, 89, 87. I got to think about that. But I had already gone to school here. I majored in real estate property management, so I already had all the classes. It was just a matter of getting transactions and so to get transactions, I had 8 years of experience. But all the transactions I had were commercial. The broker's test is all residential. The license test is all residential. There is no commercial on either one of them. So I had to go study and learn how to do residential to take the broker's test. The Kentucky broker test I just took was all residential as well. So I took a